Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we're prepared to hear argument in number 20-1420, Bilioni v. Bryant. And Mr. Butler, you may begin.
Thank you, Your Honor, and may it please the court. If the district court's ruling below is allowed to stand in this case, no whistleblower will ever speak out again about the most serious form of government misconduct, and that is excessive use of force by police, out of plain sight, and the attempt to cover it up. However, that ruling cannot stand. Luckily for the First Amendment, it cannot stand because the district court improperly gave too little value to Mr. Bilioni's speech, which this court described, and I'm quoting this court from the prior opinion in this case, described Mr. Bilioni's speech as pertaining to, quote, the role of an officer's use of force played in a man's in-custody death, directly contradicting the York County Sheriff's Office's official statement on the incident. Our court, this court, places the highest value on such speech. That comes from Durham versus Jones. Police misconduct involving excessive use of force and subsequent cover-up is exactly what Durham versus Jones speaks to, and said that is protected speech. That mistake by the district court judge threw off the entire balancing process. The entire balancing process was thrown off by miscalculating the value of Mr. Bilioni's speech and led to the ruling because of that mistake. That is especially so because the only disruption that the sheriff appeals to and the district court found was the internal investigation and the violation of a confidentiality order, which have been found insufficient in light of the value of speech like this in our cases like Durham, Andrew versus Clark, Hunter versus Town of Moxville.
Mr. Butler, I don't think we're talking about covering things up and shutting off whistleblowers. It's just a question of timing, and it's just a matter of allowing an internal investigation to wrap up and complete. I mean, I know there's a lot of suspicion of internal investigations, but they're worth something, and oftentimes they can do the job. But after the investigation is complete, Mr. Bilioni certainly could have gone and offered his view of things. It's all a matter of timing, isn't it?
Not in this case, Your Honor. I would have to disagree. And the reason that this case is different was because the sheriff had announced that for all practical purposes that the investigation had been completed, and he had arrived at a conclusion that was just false. And in the light most favorable to Mr. Bilioni, when Trent Ferris, the sheriff's spokesperson, speaks, he lies when he says that the correctional officer Moore and everybody else acted appropriately. So when Mr. Bilioni hears that, I think he's justified in thinking, well, the investigation is complete, and now that I've seen this video, and if I had only 3 words for my argument, it's watch the video. When he sees the video contrasted to what Mr. Ferris says at the press conference, he has no choice but to think that the investigation is completed and to speak out. And those 2 facts make this case unique in this jurisprudence. There's no other case that I'm aware of.
Well, Mr. Butler, let me ask you, was there ever a time that Mr. Bilioni attempted to raise a question in the sheriff's department and go up the chain of command?
He did not, because doing so would have been futile. would have been
Well,
futile.
how do we know that? I mean, it's easy to say that, but I think in this case you had investigations not only by the sheriff's office but the state solicitor, the Federal Department of Justice, and the South Carolina Law Enforcement Division, and none of those were allowed to play out by Mr. Bilioni. He preempted all of those by acting so quickly.
Yes, sir. My first response is the futility comes from Mr. Ferris's statement that everybody acted appropriately. That's my first response. My second response as to, for example, the SLED investigation, Mr. Bilioni can't be held responsible for that. That operates as a matter of law by statute. And those other criminal investigations were focusing on a completely different matter. They were looking to see whether or not anybody acted criminally. What Mr. Ferris says is everybody acted appropriately. And I think Mr. Bilioni was well within his rights after having viewed the video to say, I need to set the record straight. You know, nobody made the sheriff hold that press conference.
Why didn't he set the record straight by going up the chain of command in the sheriff's department?
Because the sheriff had already spoken on the matter when he holds that press conference. The sheriff seems to me can't have it both ways. He can't invite public discourse by telling something that's false. Invite public discourse, then at the same time want to shut it down until it pleases him for someone to speak out about it. Now, if they had not held that press conference and had Mr. Ferris not mischaracterized not only the behavior of their officers, but the behavior of Mr. Gross, the inmate who dies, blaming him for his own death, then perhaps Mr. Bilioni should have waited. But it's not only that Mr. Bilioni's right to speak out is triggered by that false statement. It's also that time is of the essence. Time is of the essence in this case because videotapes can disappear. Evidence can disappear. And it's not wrong to be somewhat suspicious when you've already seen evidence of a cover-up to think, you know, how many more times, by the way, do we have to let Officer Moore pummel somebody?
But what basis is there in the record for you to represent that there was a fear of disappearing evidence?
None. Except that he says, Mr. Bilioni does say, look, the fact that an inmate died in our custody is itself evidence that not everybody did what they were supposed to do. But no, is there evidence where Mr. Bilioni comes out and says, I was afraid evidence was going to disappear? No, but I think it's fair for us to say that time was of the essence and that he didn't have to wait for these other independent investigations, which occur in other cases too, and have not overridden the value of the speech. We have to keep in mind that the speech in this case is of the highest level of protection, and the disruption as alleged is of the lowest level. And that other mistake that the district court made was the district court, instead of seeing the evidence in the light most favorable to Mr. Bilioni, saw it and viewed it in the light most favorable to the sheriff. And that was another mistake to just assume from the fact that there's an internal investigation that's disruptive.
No, I was under the impression that the internal investigation had not been completed at the time that Mr. Bilioni spoke.
His perception, based upon what Mr. Ferris says, is that it had been completed. When Mr. Ferris says,
maybe that, a lot of times people can issue a statement and everything, but that doesn't mean the investigation was complete.
When a public employer and an elected official issues a statement like that he doesn't have to make, I think he invites public discourse on that matter. That's exactly what the First Amendment is for. It's the marketplace of ideas where there are competing viewpoints.
But nobody's saying that the competing viewpoints couldn't be aired. It's just a question of when they're aired, and you want the department is a paramilitary organization, and it has some interest in internal order and internal discipline, and it has a right to complete its own work. And then if somebody disagrees, well, they have two options. One is, as Judge Agee pointed out, to go up the chain of command. And then the other option is, once the investigation has been wrapped up, then they can blow the whistle to their heart's content. There's one other question that I had, and that is that part of this was that Mr. Bilioni is said to have lied repeatedly about whether he had leaked anything. He consistently denied that he had leaked anything, and the contention is made that the sheriff had lost confidence in him because he wouldn't come forward with a true account of what happened.
Well, and the sheriff would have been well within his rights to fire Mr. Bilioni on that grounds, but that's a jury issue. That's the third prong of McVeigh, and that's an excellent closing argument for Mr. Johnson to make before a jury. But with respect to the paramilitary,
why is that necessarily a matter of the third prong? Why isn't it a matter of the balance between the public and the speech interest? And there's a question of the remand was one, whether the sheriff had a reasonable apprehension of departmental disruption and a reasonable apprehension of disorder. And I thought that was the subject of the remand, is whether on the part of the sheriff there was a reasonable apprehension of disorder. And if someone has lied repeatedly about whether he had leaked information, wouldn't that give rise to a reasonable apprehension?
No, I don't believe so, because Mr. Bilioni is not claiming protection for that part of his speech. I think they're clearly separate, and he's not claiming protection for the lie. And
Mr. Hunter, isn't there some inconsistency in this case? There is a footnote in a reply brief that at least 6 other officers spoke to their wives about this incident while this, quote, investigation was ongoing. Nothing happened to them at all.
that would seem to me to be inconsistent. Yes, Your Honor.
Well, do you know that to be a fact?
I do not know that to be a fact. I cannot speak to that as being a fact.
I assure you, it's in a footnote in a reply brief. Do you know, one other question, I'm
Yes,
going to
sir.
ask the other side the same question. Do you know whether or not SLED was contacted or had begun its investigation before or after the media contacted the Sheriff's Department?
The SLED investigation had already begun. The SLED investigation had began on the 22nd, and I take that back. I apologize. I misspoke. Mr. Bilioni tells his wife, on the 21st, and SLED begins their investigation on the 22nd. So it was the following day.
So that would be before the press made the contact.
Yes. 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 Before SLED makes, I believe that's right. Before press makes the contact to the Sheriff's Department, I believe that's correct. I apologize for having to not be 100% on that, Judge Floyd, but I think that's right. But
so you're just to be sure, following your answer, your representation, which opposing counsel ought to answer, as Judge Floyd indicated the same question, is that the SLED investigation had begun before the press contacted the sheriff's office.
yes, Yes, that is right.
Okay, I just
That's
wanted to
right.
be sure.
Yes. And I did want to speak to the paramilitary.
Excuse me,
issue
he said
raised by
that
Judge Wilkinson.
that the investigation had previously begun before he contacted the media. What was your answer, counsel?
I believe that the SLED starts investigating on the 22nd. Mr. Bilioni tells his wife on the 21st, but the press does not contact the sheriff until, I believe, after SLED starts the investigation. No, I'm being told I'm wrong. I apologize for not having that fact straight. And it seems I'm out of time.
Well, let me ask my colleagues if they have any questions of you. Judge Agee, do you have any questions of Mr. Butler?
Perhaps on rebuttal, if you've got the time during discussion, you could check that out and see if you could give us an answer, and we'll ask counsel for the other side to do the same.
Yes, sir. Yes, sir. My apologies. Yes, sir.
All right, Judge Floyd, do you have some questions of Mr. Butler?
No, sir.
All right, well, you have some rebuttal time, Mr. Butler, and we'll now hear from Mr. Johnson.
Good morning. May it please the court. Again, my name is Chris Johnson with Gentilat, Savitz, and Bettis in Columbia, South Carolina, and I represent the Bruce Bryant, the now retired sheriff of York County. To address, I guess, first the court's question about the timing. SLED was called in as soon as the death was reported to the sheriff. So they showed up. I don't have I apologize, I don't have a timeline in front of me or the dates, but Mr. Gross, the inmate, the struggle and his passing occurred in the wee hours of the morning, from 1 a.m. to 3 a.m. I think, or maybe even longer, but it was early in the morning, and SLED was called in early that morning and arrived on scene.
And what date was that morning?
I don't know, and I can. It's in. I know it's in the plaintiff's deposition, and I was trying to find it, and I couldn't put my hand directly on it.
Okay, well, go ahead.
But it's your counsel. It's your representation that, to the best of your knowledge, SLED was called in the same day as the inmate died.
Yes, Your Honor.
Okay.
Yes.
Mr. Johnson, let me ask you about when SLED is called in to undertake an investigation, then the agency that they're investigating is no longer in the investigatory process, are they? Because it's SLED's investigation at that point.
So what was going on at that time was there were two investigations. One was obviously the state law enforcement division, SLED, investigating the death, and then there was also an internal investigation into what happened, so that to see if there were any policies that were violated, or any lessons that needed to be learned from the incident.
And so that
Was the leak
the
during
internal investigation was in the sheriff's department. Is that correct or not?
Yes, Your Honor.
Okay.
And was the leak while the internal investigation was going on?
Yes, Your Honor. It occurred while both were ongoing by the
Both the SLED investigation and the internal investigation were ongoing when the leak occurred.
Yes, Your Honor. That is correct.
Mr. Butler said that the fact that he had lied about denied doing a leaking what was it, the video or just the contents of the video that was leaked? Was it the video itself or what?
No, Your Honor. It was detailed information about what was in the video.
Okay.
And ultimately, I mean, we have plaintiff's testimony about what he told his wife, and then we have the sheriff's testimony about what the reporter who worked for the same news agency as plaintiff's wife reported into.
It's undisputed that Mr. Bilioni was the one who leaked, is it not?
Yes, Your Honor. That is correct.
That's undisputed. Is it also undisputed that he, when questioned about whether he leaked it, that he lied about that?
That is correct, Your Honor. He admitted in his deposition numerous times that he did not tell the truth.
Is that purely a matter of causation, or would the fact that he lied repeatedly figure into the Connick-Pickering balance?
Well, Your Honor, I think it goes to both. And on the Connick-Pickering balance, the sheriff. I mean, the sheriff can't be expected to think forward, 6-7 years now, and he's got to deal with what he's got at the time, and what he had was both a breach of his confidentiality policy and a breach of the policy that requires his officers to cooperate in internal investigations and to tell the truth. So I think that certainly would weigh in the balance of the relative value of plaintiff's speech. And I think the other thing to keep in mind is that this court has said previously that you can't try to parse the speech into different little buckets and say, well, this is protected and this is not protected. You have to look at it as a whole. I think the Stroman case stands for that. And so when you look at Officer Bilioni's speech as a whole, I think it's pretty clear that that when you balance the interests of the sheriff's office in not only maintaining order and discipline, but making sure accurate information gets delivered to the public, public confidence in the sheriff's office, in being able to bring these investigations to a close in an orderly manner without trying to chase down inaccurate information, which is what wound up happening, then I think it's pretty clear that the sheriff's interests strongly outweigh the plaintiff's.
Well, Mr. Johnson, what kind of disruption did the sheriff actually experience or feared?
Well, again, the standard is what he apprehended, not actual disruption, because it's a discipline case. So, but the sheriff testified at length that when he got this information that the reporter had an inside source who said that the inmate had been beaten 12 times in the head, he was obligated to go and run that down, because what the plaintiff doesn't know at this point is at the time Trent Ferris, the public information officer, gives his press conference, the SLED agents have already interviewed the officers that were involved in the matter, and they've told the chief jail administrator, Freddie Arwood, that preliminarily, they haven't finished their investigation, but preliminarily they don't see anything wrong. And so that's the basis of Trent Ferris's statement. So, and I apologize, I lost my train of thought. You had asked me.
I wanted you to particularize what apprehension, what fear what disruption he apprehended, or what actual disruption, either one.
Right. So at the time, the sheriff is under the impression, from what he's been told preliminarily by SLED, that there's not anything wrong with what how his officers responded to this situation. And now he's got a reporter telling him something that he's not heard or seen, which is that the inmate was beaten 12 times in the head, which would be a big difference from simply a struggle to restrain him. And so now he's got to go and he's got to track down where that information came from, and whether or not that there is somebody saw something that his folks didn't see. And so that's I think that's part of the apprehension. And then the other part of it is, and the sheriff testified at length about this, is that he's now got an officer he can't trust, because the officer lied when asked about whether he had spoken with anyone outside the organization about the video.
Well, Mr. Johnson, what we got here is a preponderance of the perjury. You got the spokesman for the sheriff lying, and then you say Mr. Bilione lied. There's lying going on both sides. My question is, why did the sheriff not look at that video the first thing when he got on the job? And then he would have known the truth from the beginning in a matter of minutes.
Well, that's just it. First of all, the testimony from the sheriff was that he had seen it. But the fact is, saying he knows the truth, again, he's got a reporter calling him and saying he's got an inside source that indicates that the inmate was hit in the head. You can't just ignore that, because then he's going to have media reports in the press that his officers have murdered this inmate, when that's not what happened. And the other thing, Your Honor, that I would point out is there's not lying on both sides going on. Trent Ferris, the public information officer, did not tell a lie. The information that he had that had come ultimately from the state law enforcement division was that preliminarily these officers had not done anything wrong. So that's not a lie that he's telling. He's reporting the status as it is at that point.
Judge Motz has written a concurring opinion in the Krause v. Towns of Monk's Corner. Says that the public there's no question if the public has an interest in learning about police misconduct, but she said the free speech interest in attacking the department is far stronger when the normal process of accountability fails, and says the interest is far less compelling when a police department is not even given a chance to review or investigate an incident. And says this is especially true when officers rush out to speak about an incident of which they have no personal knowledge. So that would seem to me to be relevant here, because if we were trying to hush up criticism of the department, I would never go along with anything like that. It's just a question of whether, as Judge Mott indicated, whether the department should be given some time to collect the facts and make a considered judgment. And internal investigations, people are rightly suspicious of them, because sometimes they do sweep things under the rug, but other times they're very helpful. It's always better if a department assumes responsibility in the first instance for allegations of misconduct. Now, come back to Judge Agee's point. Police officers just say, oh, well, it's futile, but they don't go up the chain of, as I understand it, it's undisputed he did not go up the chain of command. Is that right?
Yes.
can proceed if somebody doesn't help and cooperate in giving the sheriff the kind of information to allow the sheriff to make some kind of considered judgment. This could happen on a very wide scale, where internal investigations of all kinds are interrupted in midstream by someone saying, "Well, I have a different view," and then you start conducting these in the press. That's the concern that I think Judge Mott's had in the Krause thing. Nobody's interested in hushing up criticism of the police.
I agree, Your Honor. I mean, the question, I think, as you indicated at the outset during Mr. Butler's argument, is to a large degree, this is a question of timing. The sheriff's office was not given an opportunity to bring the investigation to any sort of conclusion, and instead wound up having to chase down, these wild geese, based on this information getting out and inaccurate information getting to the reporter. So I would agree. I don't think there's any way that you can run a public an institution that serves the public in this way, and not give them a chance to at least review it and respond to it.
I think your time has expired, hasn't it, Mr. Butler? I mean, Mr. Johnson? My
timer says I've got about 4 minutes, and I'm certainly happy to address anything that the court. Any questions?
You go ahead. If you have some additional points to make, you're welcome to use your time.
Yeah. Yes, Your Honor. Just a couple of them. I think we've covered the apprehension of disruption and balancing the interests pretty well. I would again reiterate that the information that the plaintiff had was very limited, and he knew at the time that he went and spoke that SLED was investigating this death, and didn't give the investigation any time to develop. And most importantly, as we've said, he didn't run his concerns up the chain of command. And I think one thing I want to be sure and point out was, as my friend Mr. Butler concedes, he says this is a unique case. Well, I mean, if that is so, this court certainly can rule on any ground that appears in the record. And I would argue that I think it's clear that there's no First Amendment violation, but if the court were to disagree, then it would certainly be a case where qualified immunity would apply, because under the doctrine of qualified immunity, we don't second guess officials for bad guesses in unique cases, but for transgressing bright lines. And there's certainly not any bright lines in this case. If there were, it wouldn't be on appeal here for the second time. I don't have anything further. I'm happy to answer any more questions the court may have, and I certainly appreciate y'all's time.
Judge Agee, do you have any further questions?
Yeah, no further questions.
All right, Judge Floyd, do you have further questions?
No, sir.
All right, Mr. Butler, thank you, Mr. Johnson, for your argument. And
thank you.
Mr. Butler, we'd be happy to hear from you in rebuttal.
You're muted.
Please unmute yourself.
No matter how many times I told myself to do that, I still forgot. So some facts that I want to clarify. Mr. Bilioni did not lie repeatedly. He lied once and he corrected it within a matter of hours to the extent that matters. And Judge Floyd, your question, I did confirm that other correctional officers did tell their wives, including the sheriff told his wife. I'm glad Judge Wilkinson brought up Krause. Mr. Bilioni did not attack the department. He told his wife, who is a member of who works for the press, about a video involving an inmate death in the facility where he worked. It was as least intrusive as it could possibly be when he says there's a video of this that you might want to check it out. And to say that he doesn't have personal knowledge, I think that that's just wrong. But if you look at the concurring opinion, which is very well reasoned, I agree, in Krause, it says, it is clearly established law in this circuit that police officers may speak about a department's efforts to cover up an incident of excessive force. And I know Mr. Johnson doesn't agree with me that there was an attempt to cover up and there was a lie, but you have to remember, we have to view this in the light most favorable to Mr. Bilioni at this point. I also have to point out.
But if your fear is covering up, it would seem to me that having somebody go up the chain of command and explain first to the sheriff everything they know, and explain any reservations about a different account of the incident or whatever. In other words, having someone go initially, only as an initial matter, up the chain of command and laying bare his concerns first internally, that's the very opposite of covering something up. That's trying to make information available, and so there's a two-step process here, isn't there? One, you try to make sure that the police department, or that the sheriff's office, when it finally makes a judgment, has a full array of information at its command. That's the opposite of covering up something. And then if you're still dissatisfied, then at that point, you can go public with it. But it's just concepts of exhaustion of administrative remedies, or just exhaustion generally. This is not a classic case of exhaustion of administrative remedies, but questions of exhaustion of one's options are very common in law. And isn't that all we're asking for here? And all we are concerned about here is a failure to exhaust? Isn't that the case, Mr. Butler?
I think that is, and I think you could always Monday morning quarterback and say somebody could have done it better, but that doesn't mean that he's required to do so. I don't know how a person is supposed to know when the internal investigation is completed, especially when the spokesperson for the sheriff's department says what he says. But with respect to the cover-up, I have to make one thing clear. When we want to talk about how people could have done things differently, why doesn't the sheriff turn over the video? Now, if you want to talk about evidence of a cover-up, and we know that not only is, and I'm sorry, in the light most favorable to Mr. Bilioni, Trent Ferris is lying. Nobody can watch that video and think otherwise. And then he refuses to turn over the video. Now, if his officers did everything appropriate and everything perfectly, why not let the world see the video? Why not? There's no reason to not turn over that video if it's going to exonerate his people and his department, and that the voting public of York County will know how he runs his institution better than turning over that video, and he doesn't do it. To this day, no one's seen it.
Well, but there's no attempt to keep the video from becoming public. It's just a question of when.
So far, it's what are we, eight years into it, that he won't turn it over. It's been FOIA'd by the press, and he will not turn it over. He kept it from SLED. SLED wanted to see it, and SLED didn't get to see it. Oh, that's right. I'm sorry. He wouldn't turn it over to SLED. He let SLED watch it.
No. The reporter drove to SLED, and the reporter drove to SLED, and the sheriff called SLED.
That's right.
Not to
right.
give it to the reporter.
I'm sorry. The sheriff told SLED not to turn over the video to the reporter. There's no doubt he doesn't want anybody seeing that video. It's cover up. And I'm out of time.
All right. Any of my colleagues have any further questions? Judge Agee, Judge Floyd, you all have any questions?
No further questions.
Okay. thank you both. We appreciate your arguments, both of you a great deal. And we'll take a 5-minute break and then head into our next case. Okay.
Thank you.
This honorable court will take a brief recess.
Attorneys, I'll place you in the waiting room for now. Thank you.
All the judges of the United States Court of Appeals for the Fourth Circuit.
All right, Mr. Todd, whenever you're ready, we'd be happy to hear from you.
Thank you, Your Honor. May it please the court, 70 years ago, Congress enacted the Immigration and Nationality Act of 1952, in which they required immigration agents to get a warrant if they had time. 45 years ago, the Seventh Circuit in Cantu emphasized that this statutory mandate should be seriously applied. 22 years ago, this court in Harrison, on facts on all fours with this case, emphasized the same and found that the unlawful arrest violated the statute. We fast forward to 2018, when immigration agents arrested Mr. Santos without a warrant. Their testimony at the detention hearing, at the suppression hearing, was that they never got warrants for these type of arrests where they believed the person had a prior deport, that it was the common practice, and they didn't need a warrant. The government condoned that by asserting to the court that...
Counsel, in the cases that you've cited, did any of those courts authorize suppression as a remedy?
Your Honor, no, Cantu did not, because they found that the likelihood escape requirement had been met because the defendant was in a vehicle. So they applied the statute and found that the arrest was lawful. In Harrison did not have the benefit of this court's subsequent Oscar Torres opinion.
I apologize. This is Sarah, the conference manager. I need to break in for a second. Judge Wilkinson, can you hear me?
Yeah, I can hear you.
I apologize. Someone had alerted that you were not on, but I see you are, so I certainly apologize for interrupting. Please go forward.
Well, thank you, Sarah.
Yes, Judge. In Harrison, they found that the arrest was unlawful. The reason they did not suppress evidence because they did not have the benefit of Oscar Torres, and they relied on case law prior to Oscar Torres that the identity is never suppressible.
Well, I mean, but both the First and the Sixth Circuit have said that the statute, the 1357A, does not authorize suppression. And how can we just supply a remedy when the statute itself doesn't provide one?
Your Honor, I think it's important to note that it doesn't matter if the statute is silent. That's precisely the situation where the court can consider supervisory authority. There are basically three paths to suppression.
But that's when you say supervisory authority, that's a pretty sort of a vague notion to ground this on, where you don't have any kind of statute providing a remedy. You can say, oh, well, a court sua sponte can simply use its supervisory authority. It's like the court be writing a statute, wouldn't it?
Your Honor, I think supervisory authority is condoned and compelled by the Supreme Court McNabb case, which specifically addresses flagrant disregard of a statute, and also by...
Well, I mean, but the Supreme Court has been very skeptical of the exclusionary rule. They've narrowed the suppression remedy quite substantially, and they're quite skeptical of it, even when they're dealing with a Fourth Amendment violation. There's concern of, that in Justice Cardozo's old words, about the criminal going free because the constable has blundered. And of course, the suppression remedy is alive and well for Fourth Amendment violations, but in terms of the Supreme Court's willingness to apply it, the court has been very skeptical. And how much, and wouldn't it be all the more skeptical if there was no statutory basis for suppression, but simply the court's own supervisory power? We'd be pushing forward we'd have some real headwinds here, and we'd be pushing forward with an extra statutory remedy, and the kind of remedy that the Supreme Court has been concerned and leery of. So isn't that a problem for an intermediate court?
Your Honor, I agree that the supervisory authority is viewed as extremely rare. However, Your Honor, once again, I believe the standard has been confirmed by the Supreme Court that if there is a flagrant disregard of a congressional mandate, I know that the Abdi and De La Cruz relied on the Sanchez-Yamas case, but the Supreme Court case of Corley, 3 years after, did recognize what the Supreme Court said in McNabb, and there was two important things. McNabb recognized that it was not a constitutional violation, and they also recognized that the statute was silent. And I think that's more appropriate, especially here, Your Honor, because as I see it, the touchstone of supervisory authority is in those rare instances where there is a flagrant disregard of a congressional mandate, and the purpose.
Well, counsel, what's your best evidence of a flagrant disregard?
The flagrant disregard, Your Honor, is repeatedly the arresting agents said they did not need to get a warrant and that they did not get warrants as required by the statute. And the government, their legal argument was the statute did not even apply. They also.
Well, do you have any testimonial or documentary evidence other than your cross-examination of Agent Swivel?
Well, on direct in pages 115, he says it was common practice not to get a warrant, that they couldn't get a warrant.
But you're relying basically on his testimony to represent a flagrant abuse for the entire agency.
I'm not saying the entire agency. I'm saying at least in the Eastern District of North Carolina, I think it's worth noting that the same agents were involved in the unlawful arrest just a month before in the U.S. versus Juan Segura case. And the government made the argument there that they condoned the practice of arresting people without a warrant.
Well, when you talk about that, the arrest here, you say this was what happened here was so awful. Well, there was probable cause for the arrest for a violation of 1326A, which prohibited illegal reentry of a previously removed individual. And this individual was deported in 2011, and he obviously re-entered the United States after deportation, and he was arrested in 2018, and the detective knew this, and he knew the prior deportation, and when he made the arrest, and so he clearly had probable cause for the arrest in light of what he knew of the statutory violation. And the warrantless arrest are particularly problematic if without a warrant, if you can't go into someone's home and arrest them without a warrant. But on the other hand, people are arrested all the time without a warrant if they're in a public place. And I thought that the officers here had waited until he had left the house and that the arrest was conducted in public. Is that not the case?
Yes, Your Honor. He was about 20 feet from the door of his mobile home.
Mr. Todd.
No, but he wasn't. He was not arrested in his home.
That's correct, Your Honor. Just out front of his home.
Mr. Todd, let me ask you this. This warrant requirement, it doesn't require a neutrally detached magistrate to issue it. It can be issued by a supervisor within the department. Isn't that true?
That's correct, Your Honor. In fact, the regulations have at least 50 different people that could authorize a warrant. It's an internal warrant.
So how hard is it to get a warrant?
It's very easy. As the magistrate judge in this case noted, that he referred to the Segura Gomez, where the judge said they could get a warrant during the lunch break, and here it was several days. Literally, it takes a matter of minutes, Your Honor. It is easy to do. I did want to address Judge Agee's question in terms of evidence of record. I would cite the Moreno versus Napolitano case from the Northern District of Illinois, pages 1005 to 1006. That sort of supports what the proffer was in terms of ICE counsel's representation to the government, that even in the civil context and deportation, they don't get the warrants as required.
Well, counsel, let me read you part of the cross-examination. I don't know whether that was you or another counsel below, but obviously on cross-examination, you're stuck with what the witness answers to your question. And the question was, is it your testimony you don't need a warrant to take the person into custody? Well, that's correct. Next question. That's the practice. Sometimes it is. This is the answer. Sometimes it is. Sometimes it isn't. That would seem to be a very weak read based upon one agent's testimony to find that there was a flagrant abuse that authorized a otherwise unauthorized remedy, in this case, suppression.
If I may respond, right after he says sometimes it isn't, sometimes it is, sometimes it isn't, he says on page 146, I can't speak for enforcement removal operations, in other words, ERO. They're the ones that handle the deportation after the person's been arrested. And he references that from 148 to 149. So when he says sometimes it isn't, the best read on that is he's referring to he can't speak for enforcement removal operations, but that was the agency involved in the Moreno versus Napolitano case, where I said on pages 1005 to 1006, they disobey the law there too.
Well, we've been talking for a good many minutes about this situation, but the basic problem still remains, and I'm just not sure that you've addressed it, and that is that the statute, and nothing that I see, permits or authorizes suppression as a remedy for a violation of the statute. And we just can't supply the remedy. And just to say that the court's supervisory authority can step in, well, under what criteria and what I don't understand what the standards are for the court to be exercising its supervisory authority. But the main problem I have is it's just extra statutory. We can't just go around adding and inventing our own remedy, and especially not when the Supreme Court is cast a skeptical eye towards suppression as a remedy. If suppression is provided as a remedy, that's one thing. But where is suppression authorized in this whole case?
Suppression is authorized, Your Honor, by McNabb and then subsequent Corley. Both of them emphasized that there was no constitutional or statutory provision, but they said it cannot stand that the executive branch can flagrantly disregard Congress, and in order to maintain fidelity to Congress, only the court is the one that can require that by suppression. Your Honor, and the statutory cases, Donovan, footnote 22, Corley, and Your Honor's case in Clenny, they had specific provisions. That's why they were tied to the statute. Just because the statute doesn't specifically address it, it doesn't prevent the court from exercising the essential supervisory authority. And I think in my reply, the history of 1357, which is why I cited the Copland case, shows that Congress knows exactly what they do when they write a statute. In 1950, the FBI had the same requirement that was taken out in 51. In 1952 is when Congress put that requirement in for immigration agents. So I think the implication is that they take it seriously. They expect the immigration agents to take it seriously, and they hope the courts will help make sure that happens. I see my time.
We seem to be picking a conflict with the First and Sixth Circuit, are we not? Because they made a point in those two cases that the statute didn't provide an authorization, and they didn't supply one.
May I respond, Your Honor?
Pardon me?
My time is up, but may I respond?
Yes, you may.
I think Abdi got it wrong by relying solely on Sanchez-Yamas. Sanchez-Yamas is specifically said from the outset that supervisory authority cannot apply. And so Sanchez-Yamas is not the be-all and end-all of supervisory authority, number one. And like I said, Corley, after that, refutes the assertion that you need a statutory provision, the way they describe it. All
right, thank you, sir.
Thank you.
You got some time in rebuttal, Mr. Todd.
Thank you.
But I'll ask either Judge Agee or Judge Floyd if they have any further questions for you now.
Not now.
Okay. Mr. Booth, do you want to give us your view of it?
Yes, good morning, members of the court. Suppression is not warranted for a violation of the escape provision in 8 U.S.C. 1357A. In Sanchez-Lamas, the court said that suppression is ordinarily authorized in 3 situations: for constitutional violations, for statutory violations where there is an express statutory exclusionary or suppression remedy, or as a matter of supervisory powers only when the violation implicates important Fourth Amendment interests. And there they gave as the sole example of a Fourth Amendment interest, the knock and announce provision in 3109, which the Supreme Court ultimately held several years later to be actually a Fourth Amendment interest. So applying the Sanchez-Lamas test to this case, the government's position is, one, there was no Fourth Amendment violation because the defendant was arrested in a public place and on probable cause, and that satisfies Watson and Santana. 1357A doesn't have an express statutory remedy for exclusion, and so that particular mode of analysis doesn't apply here either. And three, the escape provision in 1357 doesn't implicate an important Fourth Amendment interest. Let me give you a particular example as an analogy. For example, in Hodari D, the Supreme Court held that where a suspect was fleeing from the police and he threw some cocaine away as he was fleeing, and fleeing, of course, is something akin to escape, the exclusionary rule didn't apply. And so therefore, if you don't have the exclusionary rule applying when somebody is fleeing from the police, a violation of the analogous escape provision in the statute doesn't warrant suppression either. And that is why the two courts of appeals, the First Circuit and the Sixth Circuit, have held that suppression is not a remedy for a violation of the escape provision in 1357A. I would like to turn to the alternative argument that there were systematic violations in this case. On this issue, you have to look at the evidence in the light most favorable to the government. And even though the district court didn't expressly address it for some of the reasons we pointed out in our brief, this court can affirm a judgment on any ground in the record, even on a theory that the district court did not actually consider or address. There's no systematic violations in this case. At most, you have an agent who violated the statute in this case and may have violated it in another case. But there's been no showing that in all of his prior arrests, that those arrests were illegal. There simply was no showing of what the facts were in any of those particular cases. In many of those cases, maybe the escape provision was actually upheld, or maybe the defendant was trying to escape. And the officer, Swivel, also testified that some of the practices he engaged in, he did that happen was 16 years ago when he was on Border Patrol.
All right, let me, Mr. Booth, Judge Floyd raised an interesting point, and I think you do well to address it. And that is that there's a provision for, in the executive branch, to get an administrative warrant, and that wasn't a difficult thing to do, and that the officer could have gone and gotten an administrative warrant here. What do you say with respect to the point that Judge Floyd had raised in his question?
I would say the fact that the government has not sought to justify the arrest in this particular case, we decided for prudential reasons not to challenge the magistrate or the district court's ruling that the arrest violated the statute. As far as the facts in terms of getting these warrants, this is a very, very complicated area. But again, for purposes of this appeal, the government has decided solely to focus on the issue that was raised and addressed by the magistrate and the district court. We concede for purposes of this case that there was a statutory violation here.
Well, all right, but then the question arises, why could you have gotten a warrant from within the executive branch? Whatever you call them, an administrative warrant. Why not get it?
Again, the record is a little bit unclear in this case. The agent testified that he didn't usually make arrests in situations like this. But other than that, we don't have a record as to why he didn't go out and seek an administrative warrant. I guess they're called the I-200s in this particular case. Again, Judge Wilkinson, we do not challenge the finding below that there was a violation of the statute. We are focused solely on the issue of remedy.
But I mean, I would have thought your answer to me might have been that, assuming there was a failure to get a warrant within the executive branch, that there's still no authorized remedy of suppression for that failure. Is that correct?
Oh, of course. Our argument throughout is simply whether or not whether it is a failure to get an administrative warrant in this particular case, or even whether there had been any other violation of the statute. Suppression isn't authorized. It's not authorized, especially under supervisory powers, Judge Wilkinson. The court, as you pointed out earlier in questioning appellant, the Supreme Court has, one, consistently cut back on the scope of the exclusionary rule. For example, in Hudson, they said that there are alternatives now to suppression, including internal police discipline and civil suits. So if there turns out to be systematic violations or an agent is doing this repeatedly, those are the better methods rather than suppression. And the Supreme Court has also, not only has cut back on the exclusionary rule, but it's also cut back on the lower court's supervisory powers in cases like the Carlisle case, which was the Rule 29 case, in Painter, which was the Fourth Amendment case, Bank of Nova Scotia, which was the harmless error case. The Supreme Court there has said over and over again that where there have been rules enacted by the Congress, courts don't have supervisory authority to go beyond those. And here you have a statute in which Congress has specifically said, or at least has not authorized suppression as a remedy. And therefore, we believe that it would be only an extraordinary case.
Okay, so if suppression is not the remedy, what would be the remedy?
Well, for example, two of the examples that were mentioned in the Hudson case, Hudson, by the way, is cited in my brief in a footnote. The Supreme Court there said in cutting back on the exclusionary rule, the Supreme Court indicated that the internal police disciplinary measures and civil suits would be alternatives to suppression. So if it turns out that there's a case in which perhaps the ICE agents or home DHS agents are not following the statute, one of the ways is to bring that attention to their supervisor so they can be disciplined. Another thing would be, as Appellant has pointed out, is to file a civil lawsuit to try to prevent these things from happening. But suppression is not the remedy in a situation like this. I'm sorry, I don't have any further discussion. I'll be happy to answer any questions that any of the judges may have.
Judge Agee, do you have any questions of
one quick question? In the when looking at the topic of flagrant abuse as a rationale for suppression, in those cases, is it your view of the law that there has to be a important Fourth or Fifth Amendment interest, even in that circumstance, before a remedy for a statutory violation could include suppression?
Yes, I think that follows from Sanchez-Lamas. I believe the Supreme Court was intent on narrowing the scope of a lower court's authority to use exclusion as a remedy for a purely statutory violation. If you read Sanchez-Lamas at various points, they talk about how this is the last resort, suppression is not our first impulse. It noted, for example, how America seems, this is in Sanchez-Lamas, how America seems to be one of the only countries that uses suppression as a remedy for Fourth Amendment and equivalent violations. So the Supreme Court was pretty interested in Sanchez-Lamas in limiting the scope. When you talked about flagrant disregard, I believe that term comes from the Supreme Court's decision in Painter, where they left open the idea that you could have supervisory authority to suppress evidence. But the Supreme Court has moved on from that in Sanchez-Lamas, and again, in cases like Carlisle and Bank of Nova Scotia. Again, it would have to be an extraordinary case, maybe violations on a national scale, before a court of appeals would be entitled under its supervisory.
Is it fair to say there's no flagrant disregard? I agree with you. The systematic disregard has not been developed in the district court, but is it fair to say that there's a flagrant disregard of a Fourth Amendment interest or whatever when an individual is arrested in public and there's probable cause for the arrest in terms of what the officer knew, that there was a re-entry after removal and deportation? I mean, if the bottom line here is we're worried about flagrant disregard of Fourth Amendment interests and the like. I mean, what happened here really as a bottom line was there was an arrest in a public place where the officer or the detective had probable cause to know that there was a reentry after deportation. And, you know, that can't be an egregious assault upon the Fourth Amendment. If they'd gone in the house without a warrant, yeah, that's a different case altogether. If they'd used excessive force in some way, or you'd have a Graham v. Connor violation, that would be serious. But I just wonder whether this is the right case to find that something has gone terribly wrong here when there was a warrantless arrest in a public place for a known violation. That happens with great frequency.
Well, I agree with you, Judge Wilkinson. You indicated an arrest in a public place on probable cause there's no reason to invoke the supervisory power to exclude interest, because in that situation, there hasn't been a violation of an important Fourth Amendment interest. Yes, we agree that there was a violation of the statutory escape provision, but the escape provision is simply an addition that Congress has added in the immigration context. It is not a freestanding Fourth Amendment interest. As I said earlier, in Hodari D., the Supreme Court held that where a fleeing suspect threw a rock of cocaine, that the exclusionary rule didn't apply there. Well, if it doesn't apply when you're fleeing from the police, it doesn't apply when there's a violation of a statutory escape provision. And that's why the two courts of appeals have so held.
All right. Judge Floyd, do you have further questions of Mr. Booth?
No, sir.
All right. We thank you. And thank you very much, Mr. Booth. And we'd like to hear from Mr. Todd in rebuttal.
Yeah, I think you're muted, Mr. Todd.
It would be my contention, I think McNabb and Cordy support this, that supervisory authority is not only appropriate when there's assault on a constitutional right, but when there's assault on Congress. The Watson case that government counsel said on page 749, a court's duty to enforce an agency's regulation is most evident when compliance with the regulation is mandated by the Constitution or federal law. The Painter case, footnote 8, emphasizes what McNabb said, that the importance of the supervisory authority, although rarely applied, is for two things: to deter illegal executive agency conduct and to maintain the integrity of...
Well, you know, you just, and I appreciate your candor, but you just used the words, although rarely applied. And my question with Mr. Booth is if application of this of an unauthorized remedy is, if this is one of those rare cases, I don't understand how an arrest in a public place without a warrant for a known violation can be a good vehicle for what you rightly term is something supervisory authority that's only rarely exercised. But you are asking for it to be exercised in a very commonplace situation.
Your Honor, I agree it's rare, but I think it's a rare case, and rare does not mean never. Number one. Number two, there is no other remedy other than suppression because the person will get deported. So there's no other remedy. It's an easy compliance for them to do.
Well, I'm not sure there's no other remedy because, you know, that sometimes sometimes these violations can be looked into in all kinds of ways. Congress exercises supervisory authority and it holds hearings and the rest. And if there's something untoward going on, Congress can hold a hearing about it. There can be internal disciplinary procedures for someone who gets off the track. It's not clear to me that everyone is deported because they may be just confined or serving a prison term. And we have people we have individuals bringing 1983 suits from conditions of confinement. So I just don't buy the argument that it's either suppression or nothing, because I can think, as I've just mentioned, that there are three different means of recourse. I mean, they may not be your preferred, but I have a feeling that they would be. I think the Supreme Court would take note of them. It can't be. Well, I've made the point. This is not a good vehicle for applying an unauthorized remedy. It is if there's something more here, if there's but this is a fairly commonplace situation.
I'm not sure if I have any time left or not.
Well, you go ahead. I think I always think that a litigant should get the last word, so I would appreciate it if you would make some brief closing remarks. Would you mind doing that, Mr. Todd?
Yes, sir.
Mr. Todd, I'm happy to give you a few more minutes if you want it.
I'm ready to go forward, Your Honor.
All right, go ahead.
Your Honor, I read with interest. Can you hear me?
Yeah.
Yeah.
Can I be heard? Okay.
Yes, sir.
Deportation will follow and will happen regardless of whether the evidence is suppressed. Whether that be immediately, in this case, that's important to know that that's the reason why they supposedly arrested him. They used the Trojan horse. So suppression will merely prevent them from doing something that they obtained in flagrant disregard of a congressional statute, and it will accomplish the purpose for which they arrested him, which is deportation. There is no other remedy. Somebody that's in Honduras is not going to be able to raise a 1983 claim, Your Honor. And in terms of internal compliance,
I don't know that that's the case. So maybe not.
Well, they're going to get deported. That's what's going to happen in every case, Your Honor.
Well, I mean, I suppose that's one of the remedies that Congress has provided for. We have to look at what the remedies are that Congress has provided for a violation of 1326A. If someone has indeed made an illegal re-entry into the country after being previously removed, well, we have to consider the fact that, that's an important remedy too. Deportation is an appropriate remedy for a violation of this statute. That's part of the mix.
I understand.
The only problem I have is it just seems hard to get around the fact that this statute does not authorize suppression as a judicially imposed remedy. That's just as a matter of bedrock law. It is not there in the statute.
It's not there, but Supreme Court law doesn't require it to be there, Your Honor.
All right. Thank you very much, Mr. Todd. We appreciate your argument a great deal, and we appreciate Mr. Booth. I'm sorry I forgot to ask Judge Agee and Judge Floyd if they have any further questions of you. Judge Agee, Judge Floyd, do either one of you have any further questions of Mr. Todd?
No, sir.
No, sir.
All right, thank you both. We're sorry we can't come down and greet you personally, but that doesn't mean that we're any less appreciative. And you take care and have a nice day. And we will adjourn court and reconvene for our private confidential conference in 5 minutes. Thanks also to the courtroom deputy for her help on this.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges,